Oh, that was fast. Hey everyone. I'm Carol Williams with Williams Immigration, and we have a boutique immigration law firm where we help companies and families navigate our U.S. immigration system. And I wanted to go live tonight to give you guys kind of an update, things that I have been hearing today, some things to make sure that you're not doing that will absolutely harm your immigration cases. And then take some questions from you. So one of the things that we knew was probably going to happen, and we were pretty sure of what was going to be the consequences, has started happening. So the IRS has started sharing its information with the Department of Homeland Security. And a little while ago, we knew that this might be happening. We just didn't really sort of have a time frame, but now we do. And so now DHS is looking at IRS info. So, did you file taxes? What did you declare as your income? So that when they then look at your immigration application, and you say in your immigration application, well, I've never worked inside the United States, then they now have information from the IRS, from another federal agency that says that you have. And so what that could mean is applications could get denied, green cards could get denied, citizenship applications could get denied. And for really to avoid this, right, folks that are here on, let's say, visitor status. I talked about this a little bit yesterday. If you're here on visitor status, that does not give you work authorization. So if you're here in ESTA, you're here with a B1, B2 visa in your passport, that does not give you work authorization. It doesn't give you the ability to consult. It doesn't give you the ability to work. It doesn't give you the ability to volunteer. So I take calls from folks often and they're like, but what about if I just do this? And what about if I just do that? And it's all work. And I understand and absolutely empathize that people are just trying to, feel productive and work and, get out of the house, or now in these days, stay in the house, but stay in front of your laptop and be productive. But it really harms your future immigration applications. So the IRS is now actively sharing data with DHS. So that is something we should all know about. If you are here and you're here on a work visa, so let's say you're here on an H1B, L1A, L1B, O1, O1A, O1B, P, all the things, like all the entire alphabet soup that is a non-immigrant visa. And you have a hobby, you have a side hustle, you have a shop on Etsy, you are picking up a few shifts at your local restaurant, or, you're doing a little bit of consulting on the side, right? These side hustles and these hobbies, while 110% fulfilling for us, if you are here in a work authorized status, you need to double check whether or not you have what I call sort of like free range work. Like, do you have an independent EAD? Do you have an EAD that essentially says you can work for anybody that you want? If you do, great, go forth and side hustle and work all you want. But if you're here on an H1B, or you're here on an L1, or you're here on an O1, those are employer specific. So you want to be very careful that you are only working for the employer that sponsored your visa to be here. And so those are things that, let me rephrase that. Those are easy things that with IRS information, DHS can now look at. And they can look at the IRS information and see how that tracks with your I-45 application or your H-1B application or your L-1 application, right? So you want to be very, very careful about that. Working without authorization and then not being honest about working without authorization could be a really quick trip to a denial, which nobody wants, right? Like I don't want denials. You guys don't want denials. So just be aware of that. The other thing is, when I work with clients, right, I understand that folks want to, a lot of times folks want to tell me what they think I want to hear, because I want to get them an approval, right? But here's the thing, right? The facts are what they are. They absolutely, like I can't change the facts. You can't change the facts. The facts are what they are. So you've got to be honest with your attorney. If you're honest, then I can come up with a strategy, right? Or I can tell you, I don't have a solution for you under the law, which nobody wants to hear, but I'm more than willing to tell you if I think I don't have it, right? But if I do think I have a solution, right? If I do think I have a strategy, then we're both very excited about that. And we're full steam ahead. If we get to the interview, if we get to your citizenship interview or we get to your green card interview and you've held something back and the officer knows and you know, but I don't know, that's a problem, right? And it forces me to think on my feet, which is fine. Like I can do that, but it makes it really hard. And so it all potentially could have been avoided if you just gave me all the facts up front. So I understand that everybody wants their application approved, and I understand that everyone is super anxious about it. But tell me everything. Like, I always tell my clients, don't self-edit, because it is always the things that you want to edit out that you think aren't important, that your friends said, oh, you don't have to worry about that. That's not a big deal. It's always those things. It is always those things that wind up being super, super important. So don't self-edit when you're working with counsel. And DHS is getting information from the IRS. So those are two kind of big things that I wanted to kind of mention today. And I'm here to answer some questions that you may have. As a reminder, I am Carol Williams with Williams Immigration. I own and manage a boutique immigration law firm. We work with companies, we work with families. While I am an immigration lawyer and have been for over 2 decades now, I'm not your specific immigration lawyer, so I can't provide you with legal advice. I can only provide you with general information. But if you want to work with me and my team and get a healthy dose of laughter and sarcasm along the way, click the link in the bio. We're happy to have a consultation with you. All of our clients, absolutely all of them, start with a consultation so that we can figure out what exactly is happening in your case and then how we can strategize and best move you forward. Let's see what questions we have. And I think it's worth saying again, yesterday we had someone who was here for a couple of days in a row, and they had gone to their citizenship interview. And so I told them to come back and let us know how it went, especially if it was positive, right? And so it was. And so I don't know about that person. I will be riding that high for that person, my excitement for that person into my weekend, because I like to celebrate wins, truly, even if they have nothing to do with my firm. And that win had zero to do with me. But I was super, super excited for them. So I wanted to give them a shout out. So someone's asking, do driver's licenses come up during background checks? No tickets or anything. That's a good question. I don't know. If you have, I think, a significant if you have, I think what rises to the level of a criminal history based on something that you were doing in and around your car, then yes, I think that would come up. But just like whether or not you're a good driver, I don't really think that comes up. Now, if you have, if you've been arrested, if you've got DUIs, that sort of thing, that will absolutely come up in a background check. But if you don't have any tickets or no other issues, then that's not something that sort of gives me pause or makes me concerned. Can I travel with advanced parole? The short answer is yes. The better question is, should you? Advanced parole is designed for people to travel. That's why it's there. The better question is, should you? And that answer is, I don't know. I am telling my clients currently, if you have a criminal history of any sort, at any time from anywhere in the world, right now, I do not recommend you travel. Period. End of story. So I don't know what your specific scenario is. I don't know what your specific situation is. But advanced parole is designed for people to use it to travel. So short answer is yes, anyone that has advanced parole can travel. The better question is, should you use that advanced parole to travel? And that, in your individual circumstance, I do not know. What else do we have here for questions? Hold on. I'm a little slow at scrolling. Withdrawing my citizenship application is dangerous, or I guess, is withdrawing my citizenship application dangerous for my green card? I had a I think that's maybe DUI, reckless 8 years ago. At this point, the application is filed. So I don't know the jurisdiction it was in. So there's a lot that's taken into consideration. Not all state laws are the same. So does the way that particular state law is written, does it have negative immigration consequences? Each state is different. So even though we're talking about DUI, let's say we're talking about DUI in New York, California, Idaho, South Dakota, and Louisiana, they could all be, in my mind, the same. Like, you're drunk, you get behind the wheel of a car, you start driving, right? Each state's rules are written differently and will have potentially a different impact when you are then looking at an immigration application. So my suggestion to you is to reach out, have a consultation with an immigration attorney. I don't know if I would tell you to keep the application currently as it is, let it stay in the system, or withdraw it. Like, that's a whole lot of strategy that needs to happen there. So hopefully that was helpful. Next question. It's about to be a year and my husband's petition I-130 hasn't been approved. What can I do? First, I would recommend that you go onto the USCIS website, check the status, and see if it is beyond processing times. If it is beyond processing times, then I would just ping the immigration service and say, hi, what's going on with my case? Can I get a status update, please? That is what my office does when applications are beyond processing time. But processing times, I say this every time I go live. I say this all the time to my clients. Processing times depend on the type of application and the office that is processing that application. So what may be past time in one office may not be past processing times in another office for the exact same application type. How much does it cost to get back your American citizenship certificate, or can you get it back without? I'm assuming maybe without charge. maybe without a fee. I'm assuming maybe you lost your U.S. citizenship certificate, then USCIS will charge you to get a new one. They will absolutely charge you to get a new one. There is work that they have to do. There are very few applications that they do work for free. So yes, they are going to charge you to get a new one. What else do we have? My husband's 601A was not approved or denied, and they just put his case on the docket. Do you mean the immigration court docket? I'm not quite sure what your question is. Out-of-state license for 20 years, worry about being denied a green card. Lots of people have out-of-state licenses. Now, lots of people shouldn't have out-of-state licenses. You should check your state's requirements as to when you need to get a new license in that state. I don't know if that's going to be a reason to deny the green card. But I will say this, not necessarily in respect to your question, but into sort of a lot of questions that I get. When the immigration officer is looking at your application, and this is really just kind of human nature. When an immigration officer is looking at your application and they see one thing that stands out, or they see one thing that doesn't quite make sense, or they see one thing that just, is a red flag, right? The rest of the time they look at that application, they have that, like, their mind is, okay, what else is here? What else is here? So, if you have an out-of-state license for 20 years, right? My immediate question is why, right? Like, why did you never switch your license to the state that you're in? So lots of reasons why that could be the case. I'm not saying any of them are wrong or nefarious. But when you look at that, something like that from an immigration officer's perspective, like, the main question is why, right? And then maybe as an immigration officer, maybe I'm going to look more closely at your previous addresses. Maybe I'm going to look more closely at where you've worked, right? But when you see one thing, you're typically going to start automatically looking for something else. That does not mean that that something else is going to be there, but you're going to start looking, right? So kind of human nature, you're outside, you see smoke. Are you then automatically looking for fire? I kind of do. Like, I want to know what's going on, right? It's no different for an immigration officer. They see one thing, they're like, what's going on in this application? So I don't know if that's going to be a red flag for the officer. I think it would give an officer pause, but if there are other things in the application that sort of make sense, then it may not be an issue. I suspect there is a reason that you have a license out of state for 20 years. I would recommend that you have a conversation with an attorney about that to see if there's anything else lurking in your application that may be an issue. How long does it take to process a replacement naturalization certificate? Off the top of my head, I don't know. But you can go onto USCIS.gov, check the processing times for that application type, and it will give you roughly what they are processing for 70 to 80% of the same case type. What other questions do we have? In this climate, if someone under 21 arrives on ESTA and then overstays, but is being petitioned by a U.S. citizen parent, would the case be treated differently than if they arrived on a B1, B2? If someone is So that individual is an immediate relative. An immediate relative is the spouse, the dependent child under 21 and unmarried, or the parent of a U.S. citizen. To be clear, the Immigration Service, I think I'm sort of stating the obvious here, does not like when people overstay. They don't, right? Just that's why some countries, it's really hard for them to get visitor visas because people come and they overstay and they don't leave. So, however, there's also a rule that says if you enter the U.S. and you overstay, and later you are an immediate relative. So in this case, your U.S. citizen parent sponsors you, then your time out of status is forgiven. So that's the rule, period. So it will completely depend on the officer, what that interview looks like, the questions that are asked. But the rule is, if you are being sponsored by a U.S. citizen, and you're an immediate relative, then your time out of status you have to have entered lawfully. Then your time out of status is forgiven. Hello. If I got 2 co-sponsors, do each of them have to meet the income requirement, or can both income from the 2 co-sponsors to meet the... Wait, hold on. 2 co-sponsors have to meet the income requirement, or can I come both income? Maybe combine with incomes from 2 co-sponsors to meet yours. Okay, so I think we're talking about affidavit of support here. So when you haven't, so if you don't meet the income requirements to sponsor somebody, or your primary sponsor doesn't meet the income requirements, you can get a joint sponsor or a co-sponsor. Perfect. Yes, combined. Okay. So your joint sponsor, your co-sponsor, your joint sponsor, each of them must meet their specific requirements. So your joint sponsor has to take their household number plus you as the beneficiary, the immigrant beneficiary. Add that number together. Let's say their household number is 3, 4, 5, whatever it is. And then they have to show that they meet the wage requirements, the income requirements for the number of people in their household plus the immigrant applicant. So if there are 3 people total that live in the joint beneficiary's home, including the joint beneficiary, plus, so that would be 3 people plus the immigrant beneficiary. So their income would need to be for a household of 4, according to USCIS requirements. If they don't meet that, then you can get a second joint sponsor, right? But if they don't meet those requirements, the Immigration Service is not going to really, sort of allow them to be a joint sponsor, because the purpose of the affidavit of support is to ensure that the beneficiary, so the intending immigrant, does not apply for and receive federal means tested income reliant benefits, right? And so if your joint sponsor doesn't meet the income requirements, then it stands to reason from the government's perspective that they can't support you financially as the intending immigrant as well, if they don't make what the Immigration Service has determined to be enough. So we're not combining in that sense. Now, I have done cases where there have been more than one joint sponsor. That is usually if there is more than one intending immigrant. So if there is, let's say, a parent and a child, one joint sponsor can sponsor the parent, another joint sponsor can sponsor the child. So in that sense, you can have combined joint sponsors, but they're really not combined. One joint sponsor would be responsible for one person. The second joint sponsor would be responsible for that second intending immigrant. And sometimes the affidavit of support can get a little bit tricky in terms of who is and is not counted as a household member. So I hope that is helpful. Let's see here. What else do we have? Oh, let me scroll. I'm scrolling up backwards, so this is probably not the best way to do it. I have DACA and filed for an adjustment through domestic violence through VAWA. I'm wondering if that's what you mean. I applied in 2022. I was told it was going to take 2 years. My first question is always, who told you it was going to take 2 years? But it's been 3 years now. Are they really behind on applications? I don't know. Some categories are moving pretty slowly. Some are not. So if you are working with an attorney, I would recommend that you reach out to them and ask them what the current processing time is. Or you can go onto USCIS.gov and check the general processing times. If you have a My USCIS account, you can also go into that account and see what the status is. If it turns out that you are, significantly past the processing times, I would ping the immigration service and say, hey, can you give me an update? That sometimes will get your cases moving. This is a great question. Can a juvenile case 14 years ago affect my I-45 decision? Had interview I-130 approved. So a criminal history is not going to really impact her I-130. So that's why that's why the I-130 probably got approved. It could absolutely impact a 45, an adjustment of status, a green card application. Any criminal. So the question on the form is, have you ever, it's so broad, I don't have language in front of me, but it's essentially, have you ever in your life, anywhere in the world, gotten into trouble? If yes, tell us. That's really kind of essentially what it says, right? And it didn't used to be that open-ended. Yes, it could impact her case. I would recommend that you have a conversation with an attorney to see how and what the severity of that impact may be, because the severity may not be that big, right? But I would sit down and do at least a consultation with an attorney, and I would have them do a criminal analysis to see what that criminal history will potentially do to a green card application. Does USCIS use their discretion? Hold on. Does USCIS use their discretion for minors adjusting after the 60-day grace period? 12 status ended. I don't know what you mean. I don't know what you mean by 12 status. I don't know what you mean. Thank you for the rose, Cindy. I appreciate that. Can I apply for adjustment of status if I'm married to a USC? I have a legal entry. So the rule, so I guess let me answer it this way. Your USC spouse can file for you. Like, period, full stop. Your USC spouse can file for you. The questions are really, what does that application look like, right? Is it an application where your U.S. citizen spouse can file it? Can they file the I-130 and the 485 together? Do they have to file them separately? Are you in a preference category? Did you enter lawfully? Did you not enter lawfully? So lots of questions. I have more questions actually than, even sort of general educational answers to that question. So, whether or not you can apply for an adjustment of status, I would have a consult. I would speak with an immigration lawyer to find out what is the best strategy for your application. L2. Wait, hold on. I2 was actually L2. Is that what you're saying to me? Hold on, let me reread it with L2. USCIS use their discretion for minors adjusting after the 60-day grace period. L2 status ended. Parent now a green card holder. I have more questions than I have answers. That would be a consult, because technically if your parent is a green card holder, then you don't have L2 status. So your question actually your question leads me to have more questions of my own, in order to sort of dig in and really get you a good answer. I would absolutely have to do a consult with you. That is, I have more questions than I do answers on that one. Yeah. So let's talk about discretion though in general. Before we do that, hi from New York. So the Immigration Service, the officers, right? In certain circumstances, they can exercise discretion. The short answer is yes, they can, right? There's policy that, some of the policy kind of has discretion kind of built into it, right? I don't like filing an application and requesting or relying on discretion, because that leaves a lot to chance with your application. That leaves a lot to chance. So I always get a little nervous when people say, well, will they exercise discretion on X, Y, or Z issue, right? I don't know. Right? Discretion is just sort of an individual thing, but it is discretion. It is not required. And so that is filing something and sort of having no other choice than to rely on discretion. It's a hard spot to be in. It is a hard spot to be in. Filed a 751, which is the removal of conditions. Does having a spouse in the military make it faster? Not to my knowledge. You're already a green card holder. You're already a green card holder. So to my knowledge, having an active duty military spouse does not make that application go any quicker. And I know everybody, and myself included in this, right? Like I'm not the most patient person. Everybody wants their application approved yesterday, right? Absolutely everybody. When it comes to things like discretion or asking for an expedited case to be handled, right? When you ask for discretion or you ask for, and especially when you're asking for an expedite, you have to remember that what you're asking for is for the Immigration Service to take your case out of line and jump it ahead thousands of cases, potentially. Thousands. Not 10, not 5. Potentially, you are asking for your case to be jumped ahead by thousands of people. The Immigration Service works on a first in, first out basis. They process hundreds of thousands of cases every day. So to be asking to be jumped ahead of that line is a big ask. It's a huge ask, really. And I don't think I knew how big an ask that was until I worked inside the agency. It's a huge ask. And so I know that we want our cases processed quickly. I know that we want our approvals quickly. But frankly, a lot of people filed in front of us, right? A lot of people filed in front of my clients, right? So I have to remind myself, there are some days I'm like, oh, girl, you got to simmer down. Like you just filed it a week ago. Like you got to simmer down, right? So I say that because I often get questions about, how can we get something processed quicker? Can we get an expedite on this? And oftentimes the answer is no. Like really, sometimes the answer is no. Sometimes it is in your best interest not to ask for the expedite. It just is, right? Because if there is one little thing incorrect about that application, you're not getting your expedite. You're not getting your expedite. So the expedite is sometimes not all it's cracked up to be, but I think there have been situations for expedited applications that, my friends and colleagues have requested and they've gotten denied, and they're heartbreaking. But to expedite means that you've got to jump someone ahead thousands of places in line. And the Immigration Service does not do that lightly. And granted, sometimes I myself don't like the decisions that I get out of the service, but we can't. So we have to remember that sometimes our ask may be a little bit too much. So if my colleagues totally disagree with me on that, I'm okay with that. But that's what I got on that one. Let me see here. Someone's asked, EB2 visa holder, married U.S. citizen. Does me being here legally help? Does you marrying a U.S. citizen help process your EB2 case faster? No, not at all. Not at all. If you entered lawfully and you married a U.S. citizen and that U.S. citizen is sponsoring your green card, depending on which local office you're in, those cases are, in some offices, flying through right now. I had one that just went through in 8-9 months. It was less than a year. I was shocked. Happily shocked, but still shocked. But yeah, EB2 is employment. So think of EB-2 and family green cards running on parallel tracks. They do not intersect. They run on parallel tracks. So no, unfortunately, being married to a U.S. citizen does not help you. Now, if your U.S. citizen wants to sponsor your green card, your U.S. citizen spouse can absolutely do that. Let's see here. Someone is saying married in December, filed last month. I don't know what that means. I don't know what that means. Someone is saying filed Form G325A for deferred action with work permit since May. How long is the process? I have no idea. I don't know processing times off the top of my head. Every time I send my client an update with a processing time, I look it up right then and there, or my team looks it up right then and there. Processing times are fluid. I do not. There is some knowledge I choose to keep in my head. Processing times are not one of them. But you can go on to the USCIS website and look at processing times. They are fairly candid about them, actually. So if you go onto the USCIS website, you can get to it from their homepage, and they will. You can see processing times. I have a DUI, but I want to apply for my citizenship. I would recommend that you have a conversation with an attorney. Talk about spouse and bills where there are not both names, but payments come from joint bank account. All right. Listen, y'all. Live your life the way you want to live your life. I'm going to say that again. Live your life the way that you want to live your life. I say that to every single solitary one of my family-based clients who ask me questions like this. Questions like, we don't have a joint bank account. We don't live together. We don't live in the same state. We live in the same state, but we don't live in the same city. We don't have the same religion. We have a 10-year age gap. We have a 15-year age gap. We are from two completely different cultures. Generally, my answers to all of those questions are, so what? Live your life the way you want to live your life. That's it. I'm going to ask, as your attorney, why don't you live together? Why do you live in the same state, but you don't live in the same city? Why do you live an hour apart? Why do you live 30 minutes apart? Why don't you have a joint bank account? Right? I'm going to ask the questions, and then I'm gonna come up with a document list that helps us show that your relationship is valid, that your relationship is not a sham marriage, that your relationship is not just to get a green card, right? But applications are approved where folks live in different states, where they live in the same state, maybe different city, where they don't have joint bank accounts. No one marriage, or I should say, no two marriages operate the same way. They don't. So I tell my clients, your job is to live your life. My job is to dig into your life and ask you questions about why you're living the way that you're living. And then we present documents that hopefully will get the officer to be able to say, okay, great. And they check approved. That's my job, right? Your job is to live your life however you want to live it. And if the way that you're choosing to live your life is that only one person's name is on the bills, or maybe you've split the bills in two, and some of the bills are in one person's name, the other bills are in the other person's name. That's my answer to that usually is, so what? Live your life the way you want to live it. Now, if you've got like all the red flags in one relationship, I'm gonna ask a lot of questions. But just because the bills aren't in both names, there are some utilities, some companies that will not. They refuse. It is their company policy. They don't put two names on a bill. And they don't care that I would like two names on a bill. They don't care. Their policy is you get one name. You get one name on this. You get one name on this account, one name on this bill. I don't care if there are 5,000 people living in that home. So again, live your life the way you want to live your life. Work with an attorney and have that attorney help you submit documents that are helpful for your case and how you are living your life. But no one should be living their life doing things on a daily basis just to show what they think the Immigration Service wants to see. So I hope that was helpful. It's sort of one of my pet peeves. I just want people to just live their life. Just live your life, right? Like my job is to explain how you're living your life, but just live your life. Has the new administration made the process longer? Applied for I-130 for 2, unmarried, 19 and 23. I think so. Processing times really depend on the type of application and the office that is processing the application. Some offices right now are moving fairly quickly. Some are not. Some of that probably has to do with volume of cases in the office. I think some cases are taking longer because of the extreme vetting initiatives by the current White House. But I'm not, in my practice, so it's just my practice, I'm not seeing cases that are taking substantially longer than they were prior to this administration coming back into office. In fact, actually, some of them are like moving lightning fast, quite honestly. But if I talk to colleagues, some of their cases may be taking longer. But I think the administration has been very transparent in that they are doing more vetting of applications. When we talk about applying for visas at consulates overseas, I do think that process is going to take longer. I don't think the interview itself may take longer. I think getting the appointment may be a little bit more of a challenge, and you may have to plan a little bit more. They have removed pretty much, it's like 90% have removed interview waivers. So most people are now going to have to get an interview when they are applying for visas overseas, even if it is in the same visa category in which their last visa was in. So if you are having if you're having more people appear for an interview, that's going to take up the visa spots, the visa application spots a whole lot quicker than it has been in the past couple of years, where there was an active movement to not interview everybody in order to work through the backlog. So I do think getting those appointments is going to take a little bit longer, but I haven't honestly seen, and again, even that depends on the volume of applications seen at a particular consulate. Some consulates, have a ton of interviews, have a ton of applicants, and others don't. So I think there's a lot of things that can make processing times fluctuate. regardless of the administration that is in office. But this current administration is very clear. They are doing much more security vetting, and for some cases that may increase the time. So yeah, so I hope that was helpful. My crystal ball is a little cracked and cloudy right now. Let's see what else we have. Is it really true that as of August 15th, you have to pay taxes in full, not accepting payment plans? I have not heard that. I don't know where you heard it. I have not heard that. That has not come across my desk. How difficult are interviews? I think difficult is a relative. I think your question is relative, right? I have clients in the past that have been terrified of an interview, and then I have other clients that go into an interview like no big deal. So it really depends on how you feel about going into an interview. That's really the best I can answer that question. There are some folks that are terrified of interviews, and therefore to them those interviews are painfully difficult. Other folks I've worked with are like, it's fine, it's an interview. What I will say about any immigration interview is it is a conversation. It's a conversation, right? Granted, a weighted conversation, right? Like that officer has something that you would like an approval, but it's a conversation. You go in, you sit down, you have a conversation. Hopefully you are prepared and well prepared for that conversation. But at the end of the day, it is a conversation. Okay. So the tax question goes to, you're asking about good moral character. So good moral character, the way that they are processing naturalization cases when it comes to good moral character, that is changing. Previously, good moral character, the analysis by the Immigration Service was, have you done things that show that you do not have good moral character, such as criminal history, not paying your taxes and not having a payment plan, not taking care of your children, not adhering to child support orders in the US or outside of the US. Now what they are looking to do, and it's a fairly significant policy shift, is they're not simply looking for the absence of things that cause good moral character. They're looking for sort of positive factors that would say that you have good moral character. So are you a member of your religious organization? Are you a volunteer? Are you, what are you doing? What are you affirmatively doing that says that you have good moral character? Are you volunteering? Are you tutoring? Are you coaching a little league team? That sort of thing. Are you feeding the homeless? All the things that you can do to show that you are a good person. So it is a different way to evaluate good moral character. And so frankly, we haven't really had that policy change tested yet. So I don't know what that will look like moving forward. I mean, we're all trying to figure out how much positive evidence do we include in an application now. We won't know until a couple of applications go through, get sent back, have more conversation, so that is in flux. So I don't know whether or not a payment plan will, or the absence of a payment plan, right? I don't know how that's going to be viewed under the new policy. But I would think if you had a payment plan, I would think that would show that you are doing what you need to do. But I have not seen anything that says that all taxes must be paid in full or you will not be considered to have good moral character. I personally have not seen that. Nor have my colleagues pinged me about that. So chances of getting approved for marriage-based green card if F1 is expired and I-20 was terminated completely depends on your category of green card. Completely depends. That is a question that is better asked during a consult, where an attorney can really dig into your entire immigration history and see what else is going on. Why was your I-20 terminated? That's like big for a school to go in and terminate your I-20. I have way more questions than I have answers for you. Mickey, I hope that was helpful. How long is the waiting time for a marriage green card after an interview? No one likes it when I say this, but it's going to take as long as it's going to take, right? There is no specific wait time. There is no specific processing time once you have had your interview. Oftentimes after the interview, or oftentimes at the end of an interview, an officer will say, your case has been approved, or I'm recommending your case for approval. I'm going to request additional evidence. We need to do some additional processing on the back end for your case. But even if the officer says at the end of the interview that your case is being recommended for approval, there is still housekeeping that has to be done on that file on the back end after you leave the office. And there is no set time for them to do that. So 30, 60 days, it's not terribly concerning for me, right? Just in what I see, 2 years, 3 years, concerning for sure. But we've got to be patient, right? Like you are, and I get it. You are at the home stretch. Like you feel like you are almost done, right? I get it. But there is no, there's no set waiting time for that. There's absolutely no set waiting time. And I think we have to remember that like 30 days in the immigration world, while that seems really long in terms of waiting, is like 2 seconds to the agency. That's like a blip in time. So I know you don't like that answer. But that's kind of the answer I give my clients too. YouTube is saying, I got an RFE on EB2 NIW. Do you help with that kind of visa? I do. My office does help with EB2 national interest waivers. You are welcome to click that link and schedule a consult, and we can see how we can help you. I can take me a couple more questions. I gotta go get some dinner, y'all. Are 7 letters, oh, I love this question. Are 7 letters of recommendation good enough to prove good moral character? There is no set number of letters, of support letters for any application that is required. So my honest answer to this, and what I tell all my clients, is the more the merrier. The more the merrier. Give me everything that you have, and then let me sit down with everything and figure out how best to tell your story and present that application to the Immigration Service. But there is no set number that is good, bad, or otherwise. Someone's asking me if I'm Jamaican. I am not. What are the chances of getting a marriage green card approved when you have a baby together? Having a baby together is one piece of evidence. It is not a slam dunk that application is going to get approved. It is one piece of evidence. Is it stressful for an N400, which is a citizenship interview? Stressful or difficult depends on you. Some people completely don't like interviews. Some people are like, whatevs. Let's go have a conversation. Generally, I find that those interviews take about 30 to 45 minutes. Of course, they can be shorter, they can be longer, but that's kind of generally how long they take. But your anxiety and or stress level is going to be what it's going to be. It doesn't matter how I consider the interview. It doesn't matter what, somebody else considers that interview to be. It is that stress level is yours and yours alone. So I can't tell you if you are specifically going to find it stressful or not. I will say this. However, the more prepared someone is for an interview, the less stressed out, the less anxiety they bring with them to that interview. So I know for my clients that are super stressed out, we do a full-on mock interview, whether it's for a green card or a citizenship application. I will do full-on mock interviews for them so that they have a sense of what exactly happens during an interview, the types of questions that they will get. Every single one of my clients has said at the end of the day, that was helpful. That was helpful in helping them ease their anxiety levels. And so my office will do that, even if we will do mock interviews, even if we did not prepare the file for folks, so that they go in putting their best foot forward. What else do we have here? I did my marriage-based interview over 2 months with no decision. Should I be worried? Not necessarily. Completely depends on the office that has your case and their caseload. We're also coming off summer. Listen, y'all, we are coming off of summer. Everybody goes on vacation in the summer. Everybody, including USCIS officers. And you know what doesn't happen when they go on vacation? Work fairies do not come and do their work for them. Even though I would love for work fairies to come and do that. Listen, I would love for work fairies to come and do their work and my work. Work fairies don't exist. They do not come and do their work. If that officer was on vacation for 2 weeks, guess what? Your case didn't move. So in the officer's mind, your 2 months is now 6 weeks, right? And so for them, 6 weeks, not, a case not moving off their desk and they've been on vacation for part of that. Okay. Right? Like, again, I would love for all of my cases to move super fast. The fact is they just don't. Some of them just do not. Some of them, again, right now are moving lightning fast, but lightning fast could be 8 months, right? And so I'm thinking that's super fast. My clients have been riddled with anxiety for 8 months, right? But 8 months is better than 2 years. 8 months is better than 4 years. So sometimes you gotta kind of see the silver lining in things, and understand that there are thousands of cases that are going to be processed before yours. And so sometimes, myself included, I just got to be a little more patient. But I get it. It's hard. It is hard. It is hard to be patient. My family tells me I'm very impatient. All right. I think I'm gonna do like 1 or 2 more, and then I'm gonna go get some dinner. We had an I-751 combo interview over a month ago and no response. That sounds about right. That doesn't throw up any red flags for me. Especially if you're working especially if your interview was in a high volume office. Let's see here. Mickey, you are very welcome. What else do we have here? Filed an I-130 for my wife last year, expecting our child now. How to update my case to add your baby. Add our baby, sorry. I don't know that you have to do that. I suspect, here's what I suspect. I suspect you're asking this question because you think that it is a slam dunk to approval land if you can show that you have a child together. It is not a slam dunk to approval land if you have a child together, number one. Number two, an application is a snapshot in time. It is a snapshot of the day that you filed. So if you did not have that child on the day that you filed, you can talk about that child at the interview. But when we are looking at making corrections or amendments to an application, we are trying to amend the situation that was in place at the time the application was filed. So that is how I think about that. How long does it take for them to approve a 601 waiver? I don't know off the top of my head. I would go online and look at the USCIS processing times. I don't know. September. I did my interview back in September. Back in September 2025. We're in September of 2025, so maybe September 2024, 23, one of those. I was found inadmissible because of the COVID vaccine. I'm thinking because of the lack of the COVID vaccine, maybe. So they directed me to apply for a 601A. The COVID vaccine is no longer required. So I would have a conversation with an attorney and see, you meant 2024. Okay. I would have a conversation with an attorney and see, one, what the current status of your application is, and two, to see if it can be, if your denial due to inadmissibility because of not having COVID could potentially be changed. And I don't know the answer to that off the top of my head, but that is something I would have a conversation with an attorney about, and they can do some quick research and see what the latest and greatest is on applications that were denied because people did not have the COVID vaccine. If there is a part of that policy that speaks to applications that were denied previously solely because of that reason. Now, if there were 5 other things that it was denied on, then that's, you're probably just gonna have to refile or whatever. But yeah, I would have a conversation with an attorney about that. How can people overcome the new neighborhood interview policy? I don't know that you overcome it. The new policy is what it is. If they come into your neighborhood and they start asking questions, then they're going to come into your neighborhood and start asking questions. It's not something that you can really stop them from doing. So I don't know that you overcome it. At least in the way that I think of the word overcome. Here is. Does NVC, which is National Visa Center, send the welcome letter when they receive the I-129F, which is the fiance visa, from USCIS? USCIS will send the approval of the I-129F to NVC. NVC will then reach out to the U.S. citizen spouse and the fiance overseas and start asking for a host of documents. Once NVC gets all of those documents, they will then schedule an interview at the consulate overseas. Then you go in for then the individual goes into the consulate overseas, has the interview, enters the U.S. as a K-1 non-immigrant. Then you have 90 days to get married. After that, you can file for an adjustment of status. Who is eligible for self-petitions? Self-petitioning green cards, I'm assuming you mean through employment. EB1, extraordinary ability, is a self-petitioning green card, as well as EB2, national interest waiver. Those are two self-petitioning green cards where you do not need an employer to be your sponsor. I think I will do one more before. Oh yeah, we're gonna end on this question. This is a good one. Once perm is approved on my EB3, how long does it take to get a green card approved if I am Mexican? There's a lot in this question. So I'm going to kind of give you a very high level response. The length, so perm and EB3, for folks that don't know, EB3 is third preference category, employment-based green card. Perm is the first application in that green card process. There are 3 applications in that green card process. Perm is just the first of 3. So your question is, once the perm is approved, how long does it take to get your green card approved if you are Mexican? The approval, or I guess the time frames from start to finish for an EB3 depend on what country you are from. Every month we have the visa bulletin, which is put out, and every month that tells us where you are in line. Your place in line is determined by the day that your perm application was received by the Department of Labor. Countries that typically have a lot of green card applications are slowed down. Their processing takes longer. Think of it as buffering with cable and internet, right? So the more cable you use, the more data you use, at some point they start to slow you down. Think of the EB3 process the same way. The countries that send or have the most applications are slowed down. The most green card applications are slowed down. Mexico is one of those countries. Yeah, so Mexico is one of those countries. So once you file, or once you get your perm back, then you file your I-140. You get your I-140 approved, however long that takes. Then there is a wait time between the approval of your I-140 and when you can file that adjustment of status. That wait time changes every single month. So EB3s, it is best to become very familiar with the visa bulletin and check the visa bulletin. I mean, you can certainly check it every month if you want. I would probably not start checking it until you file your I-140, because before that, it doesn't really impact you, because in order to get to the adjustment application or consular processing, your I-140 has to be approved. So I would get myself at this point, if your perm is still processing, I would get myself familiar with the visa bulletin, but I wouldn't start sort of stalking the visa bulletin until you file your I-140. But yeah, so if I look at the visa bulletin for July of this year, which is obviously not current, the most current one is September, but July just happened to pop up. EB3 Mexican nationals, they were processing cases where they were filing adjustment cases where the perm application was filed before April 1st, 2023. So keep in mind that the movement of the visa bulletin is not always 1 month forward. it can jump forward several months. It can jump forward several years. It can jump backward a month, 2 months, or several years. So that's why I say stocking it before you've even filed your I-140 is it doesn't really sort of help you. So that, my friends, is what I have for tonight. We've been on for a minute. We've been on for a little, just over an hour and 15. So I'm going to go make some dinner. I got a little list over here of work I still need to get done tonight. So again, I'm Carol Williams with Williams Immigration. I'm an immigration attorney here in South Florida. I work with clients all over the country and all over the world. I will be back live again Monday evening. I go live Monday through Thursday evening. And then I go live Monday mornings over on LinkedIn. Also on Monday through Thursday night on TikTok, Instagram, Facebook, and YouTube. Monday mornings, I go live on LinkedIn and Facebook and YouTube. The Monday mornings are much more geared towards my employers, my employees. So we talk a lot about EB1s, 2s, 3s, non-immigrant visas, H-1Bs, L1s. Evenings are usually more so geared towards family cases, but we can certainly talk about employment-based cases in the evening as well. Not too many people ever really ask me questions Monday morning. It's kind of early. It's 8 a.m. I think people are still they don't have all their caffeine in their system yet. But you're more than welcome to join me, obviously, on Monday mornings over on LinkedIn as well, and here on YouTube. I do not do TikTok Monday mornings though, so there's that. But if you are interested in working with myself and my team, know that we do laugh, because sometimes you have to laugh from crying, and we sometimes can get pretty sarcastic about the whole situation. So, but we work really hard for our clients. All clients, before they are clients, we always have a consultation with them so that we can figure out and ask them questions, what's going on, all the things, and then we come up with a strategy. So if you're interested in working with us, feel free to click the link in the bio, get that scheduled. I'm more than happy to chat with you there. And thanks a lot, guys. This has been fun. I will see you again Monday morning and again Monday evening. Have a great night. I'm going to go get some dinner before I finish out a few more things for work. Talk to y'all soon. Bye. And thanks for hanging out. This has been fun, as always.